My name is Randy Toch, and I'm with Hoge Fenton. We're in San Jose, Pleasanton, and San Mateo, and I'm based out of San Jose, except when I'm in Pleasanton or San Mateo. And I do real estate and land use transactions. So I will be covering most of the anti-deficiency statute issues. And my amazing colleague, and I'm going to get the last name pronounced right, rhymes with Brook, Darya Druch. Got it! Okay, Darya.
All right. I'm a bankruptcy lawyer. I have an office in Oakland, and I've been a bankruptcy lawyer since 1988.
You were 12?
I was 12.
All right.
I was a child prodigy.
So here we go. Real estate finance. What are we going to be talking about? We're going to be talking about when a loan has gone into default, what are the remedies of the creditor, and what are the abilities of the debtor to say, take the property, we're done. All right, so I've given this once before, not with the bankruptcy stuff, and not just, she just blows me away. But, and so starting with the most basic, what is a deficiency judgment? Let's just make it very clear that what we're talking about there is how do you foreclose on the property and take money? The property itself is not worth enough to pay off the debt. And so this formula down here that we did at the bottom is our cheat sheet, way of Gilbert's, for those of you that are old enough. Summary is, what is a deficiency judgment amount? Take the loan balance, whatever it is when you started this action, plus the allowed cost by statute, whether it's attorney's fees, trustees' fees, whatever, and then you're going to subtract, and this is where we get to have fun, the greater of the foreclosure sale price or the fair value. So a deficiency judgment, let's start with the most basic thing, is going to have a fair value hearing. All right, so that is going to be with a judicial foreclosure, meaning a court supervised. A non-judicial foreclosure, not court super, what a surprise. Okay, but the difference is going to be, as we get into this, that on a non-judicial foreclosure, there is no deficiency, it's done, it's over, that's it. All right, so now, you'll notice that I'm quoting the esteemed authority Toch's Law Dictionary because I could not find any definition that did a journeyman's job of explaining the difference between recourse and non-recourse. Recourse means you might be able to get a deficiency. Non-recourse means you can't. All right, so let's talk about that because that is really, well, let me get to that in a minute. The entire crux of this talk is when are you eligible to get it, and then how does it play out? So recourse debt is going to be, well, let me go the other way. Non-recourse debt is going to be because the party said no recourse, which can get written into a lot of loans. And a lot of borrowers insist on it. Your only remedy is to take the property. The other kinds of non-recourse are the statutory non-recourse, which is what we're going to be talking about here. But never forget, the parties at the time of making the loan can always agree that it's non-recourse.
Of course, the borrowers have equal power as the banks.
That was a joke.
Okay. Now, I'm doing this because there are two things that have changed for those of us that are, learned this a long time ago, that are the takeaways from this talk. The rest of it is going to be pretty basic. All right. Non-recourse debt was purchase money debt on an owner-occupied residence, 4 units or less. And the dirty little secret was the minute you refi, it became recourse debt. That has changed. So we're going to get to that. So just if that's a new one for you guys, it's the new CCP 580E. Okay? So just that's takeaway number 1 from this. There's a tracing now. We'll get to it, but in other words, what portion of the refi is allocable to the original purchase money that is still going to be non-recourse? We have no idea how that's going to work when you've refied 3 or 4 times and you're trying to chase it down. But if we have time at the end, I'll throw out all the ideas I have. Okay, the new law says the proportion of any refi loan that is traceable to refi of the original purchase money is also going to be treated as purchase money. All right. Short sales. The other takeaway from this, the change in the law, is it used to be that if a lender consented to a short sale, meaning, sure, we're not, the loan is $50,000, we're only going to get 25 out of the sale, but you go ahead and do it, they still have their rights to go after the other 25. We're going to find that that law has also changed, that now it's if the secured property is residential, 4 units or less, and it does not say owner occupied. That is, oh God, I made a mistake, sorry. This is 580E. The other one is in addition to 580B. My apologies, guys. 580B, they added paragraphs B and C on the tracing the purchase money. 580E is the short sale. All right. So the new law says a lender whose loan is secured by a personal residence that consents to a short sale gives up their right to get a deficiency. All right. So now here we go. Let's talk about deficiency judgments. Does it matter what kind of property we're talking about? Borrower's personal residence, you already heard me talk about that. Or is it a commercial or residential income producing property? And 3 is kind of a gimme, that it was sold at a non-judicial foreclosure sale. Well, the answer to that is yeah, hell yeah, it matters. Okay, so here are the 3 types of loans that I like to talk about. One is no sale involved. That's the very first dot up there. I'm saying it's basically a loan from me to you and you're pledging real property as collateral. There is no sale involved. Second, number 2 is a purchase money loan funded by a third party, usually a bank. And that's going to break down into, is it residential, owner occupied, or any other kind? And then the last one is going to be a purchase money loan that is seller financed. Those 3. So again, from the top, a loan, no sale involved, the property is just collateral. A sale, seller financed. A sale, third party financed. And under third party finance, we're going to split it into owner occupied residential and everything else. Okay, so here we go, 580B. And I hate to read code, but there's no other way to do it. No deficiency shall be owed or collected, and no deficiency judgment shall lie for any of the following. Under a deed of trust or mortgage given to the vendor, i.e. the seller, to secure payment of the balance of the purchase price of that real property. What does that mean? Any seller financing of any real property, residential, non-residential, vacant, doesn't matter. All right, so no deficiency at all on a seller finance loan. So anytime you're writing a seller finance loan, the first thing you say to the seller is make sure that if they're your client, that they understand there is a tremendous amount of risk here to them if it goes down in price and they really are planning on living on that income. Okay. Then the next one is the one that I was talking about before. Under a deed of trust or mortgage on a dwelling of not more than 4 families given to a lender to secure repayment of a loan that was used to pay all of the purchase price of that dwelling occupied entirely or in part by the purchaser. Again, this is third-party loan, owner-occupied 4 units or less, non-recourse by definition, and this stuff that's in blue is the new law that I was alluding to that I first said was 580E, but I meant was 580B. For purposes of B, a loan described above is a purchase money loan, and B here is the new law. No deficiency shall be owed or collected, and no deficiency judgment shall lie on a loan that is used to refinance a purchase money loan. Remember, purchase money loan was just defined in A3 as residential 4 units or less. All right. So we now have the issue that I've talked about of how do you keep track of that? So we're going to be in a position where, I mean, goodness knows, somebody refis their house. I mean, very few have paid off their entire original purchase money mortgage. Okay, so, I mean, we can throw it out. I mean, we're a small group. We'll start with, let's have the escrow make sure that the closing statement given to the lender reflects the payoff to the original borrower as part of that loan proceeds, because at least now we got, I've heard other people say, let's go as far as to say, well, let's make it 2 loans. Let's do 1 loan, which is strictly refi, only of the balance due of the original purchase money loan. We'll take a deed of trust for that. Now let's do a second loan for the new money that's going in, because that's full recourse. Okay, now that gets you into a problem of if you foreclose on the wrong one.
Yeah, they merge.
Do you do it from separate lenders?
But an escrow statement is always going to show the payoff demand from the underlying loan. So you're always going to have a line on there that shows the dollar amount they paid off on the first loan on the house.
Not on the lender's closing statement generally. And I'm just saying, you're right, the borrowers would.
But the lender would have, yes, they may not. Yeah.
What if the payoff-
That's
what if
the
the-
point I'm trying to make.
And what if the payoff of that first loan was really a payoff of an already refinanced loan? So it looks like like the first purchase money, but
Oh,
it's
yeah,
not really.
you're right, they've already
it's not-
refied
it's not
twice
really-
before that.
It's not really the purchase money.
Oh.
You'd have to go back and pull the first deed of trust that existed and hope that that bank still exists and has a record of how much they received from the first payoff when they were cleared. Because all those deeds of trust are recorded, so you know who the lenders were, or at least who was managing the money, and you'd have to trace that and hope they still exist.
Can we all agree what a quagmire it is, that it's going to have to be, because of course, the borrower is going to say, well, it was all purchase money. Yeah, that cruise I took around the world now, that was separate money. All right. Last thing I want to bring you back to, because I'm just raising the issues so we all get where we're going now, is, I didn't even talk about how lovely these numbers are. For those of you that are new, the CCP 580BA, there's nothing else like that, it just cracks me up how they numbered these, or lettered them. But C, the fact that no deficiency shall be owed or collected under A or B does not affect the liability of a guarantor, pledgor, or other surety. Okay. So now let me give you a hypothetical. Let's see, I'm doing seller financing, right? And that is covered under A2, right? Okay. So I'll tell you what, you want to put your property into an LLC anyway for liability issues. So I'm going to instruct you, you go create an LLC, and that'll be my borrower. But I want you to personally guarantee that loan.
You just screwed yourself.
Yep,
Why?
because you're now guaranteeing the loan. You're personally liable where the LLC may not be.
So we have, but this is going to be, I'll get to this in a second, but this is where we're going to have the doctrine of reverse piercing the corporate veil. We'll have some cases where it will be the borrower, or the guarantor actually, saying that I am the alter ego of the LLC, and therefore pierce the corporate veil, please, so that, or the LLC veil, so that I can have the protection against that very thing that we're talking about, but okay. Now,
So would the answer be from a debtor's protection that you buy the property in your individual name and then you transfer it to the LLC?
Yes.
And then you
'Cause-
guarantee it personally, and then,
Well, you're already on the
loan.
note.
Right.
You're in fact in default to the loan when you transfer to the
Right.
LLC, but the
Right.
lender ignores that part and lets
Right.
you do it.
But if you're already on the loan as the original buyer, then there shouldn't be any recourse against you.
That's what Darya is suggesting.
In a residential
In a
4 units or
Right,
less.
right.
Or seller finance.
Or seller finance.
That's why I use seller finance, because the LLC is much more common in a commercial situation than it would be in an owner-occupied residence, but it could happen.
And most lenders now are willing to accept the LLC as the buyer change at the last second, where they didn't used to be at times.
Let me hit 580D, because I need to come back to this. All right, so 580D is the one that says in a non-judicial foreclosure sale, there is absolutely no deficiency. No deficiencies shall be owed or collected and no judgment rendered in any case in which the real property has been sold by the mortgagee or trustee under power of sale. Again, look at B. That is almost word for word the same language that we had above in 580B, saying if you're a guarantor, that's why I lumped the two together. That concept. So these are the reverse piercing the corporate veil cases. Cable versus Harvey and California Bank and Trust versus Lawler. Again, the idea is, for the most part, what we're saying is this is a borrower's remedy against enforcement of the guarantee. But let me come back to this Spangler versus Memmel. This is the big exception to the no deficiency on sale, vendor sale, seller finance sale. This is the situation in which I always call it just Widow Wanda, sold her property to developer Dan and did a carryback note, which was basically going to be her income for the rest of her life. Developer Dan says, hey, Widow Wanda, I have this great idea. Let me do a development on the property and then we'll both make a bunch of money and you get paid off out of that, and all I need you to do is subordinate to the construction loan. Well, not hard to imagine. The construction lender foreclosed and Widow Wanda was left with nothing. The courts in the Spangler line of cases just simply treated it as if it is no longer a seller financed loan. And honestly, for those of us that read code, this is completely judge-made. I found out about this sort of the hard way, where when an attorney on a case said, you haven't read Spangler, have you? And so Spangler is the one that let Widow Wanda bring her action based on the fact that the security had become worthless and she was allowed to, notwithstanding the fact the loan itself would have been no deficiency, they brought it out of the seller financing exception. The flip side of that is this 89 case, Boyle versus Slaney, which said, no, this is not a new exception to 580B. That was a situation where they completely monumentally changed the deal. And if the actual deal from the beginning is that you're going to subordinate to something, then you subordinated to it and you took that risk. So just hold on to it as if, so Boyle would be the situation in my mind where the bank is funding 80%, the seller's carrying back 10, okay, and the buyer's putting 10% down. So that 10%, which was subordinated, is part of the purchase price and is a true seller finance loan and would still be subject to the anti-deficiency rule. Did that make sense? Mm-hmm. Okay, so what's left of Spangler is a change in the deal. Just don't do it. Okay, now we're going to talk about, now that we've talked about anti-deficiency, and I'm going to restate one, by the choice of the parties, by agreement. It's in the note, it's in the deed of trust, there shall be no deficiency judgment. Statutory, or the creditor, which would have had the right to get a deficiency, opted to do a non-judicial foreclosure. and that's it, they're done. So now we're going for a deficiency, okay? So this is where it gets really interesting. The one form of action rule, which is so terrifying, is actually a creature that was created for the creditors so that they didn't have to bring separate actions to foreclose, an action on the note, and finally an action for possession. There shall be but one form of action. Okay, we're about to turn it over to my esteemed colleague here, but I'm going to come into the code section. There can be but one form of action for the recovery of any debt or the enforcement of any right. What is that one form of action? It's a judicial foreclosure action. Okay. What do you need to do? You go in, you file it as one action for the foreclosure and collection of the debt under CCP 726A. What does it mean for the borrower? It means one, security first. It means that they will do a court supervised sale. That's it. Oh, come on, back. Yeah, wrong direction. Okay. So I'm on the second line there. In the action the court may by its judgment direct the sale of the encumbered real estate and the application of the proceeds of the sale to the payment of the costs, blah, blah, blah. And then the green part, upon application of the plaintiff, notice they have to come back to court at any time within 3 months after the date of the foreclosure sale and after a hearing at which the court shall take evidence on the value. This is the fair value hearing. So now what we're saying is, one, you go into court, ask for the sale in your full complaint. The sale is done. The next step is to go back into court within 3 months and request the value hearing. The value hearing is going to be, believe me, the borrower is going to be saying, oh, they sold that property for $100, it was worth $10 million. So there's a referee appointed. I believe somewhere in here it says they use the same sources as a probate referee. But the idea is that's where we get down to that bottom line, the in green, greater of the foreclosure sale price or the fair value. That's what you get your judgment for. And you also have one other thing, which is the redemption rights. The redemption rights, which are only on a judicial foreclosure, not on a non-judicial, is, if I got it right, you have a year to buy back your property for the sale price plus whatever the buyer at the foreclosure sale put out. I can't tell you I have a lot of experience with it, but I've read the words. And it's a year if it was sold for less, and it's 3 months, I believe, if it's sold for enough to cover the loan. I think that's how it works. And I'm going to add one other reason to go judicial, which I do run into a lot, which is creditors that have no intention of taking it all the way to a foreclosure sale through a judicial foreclosure will use this process to get a receiver appointed and then do a non-judicial sale and then dismiss the judicial foreclosure.
Why would they do that?
Because they don't want, at this point, all hell's broken loose. They don't want the borrower pocketing every penny of rent that they believe should be going to pay down their loan. So they get a receiver appointed to get into the cash box. And I give you the clicker.
And at that point also, I'm assuming that they believe that the property is not worth enough to pay off the loan, and that there is perhaps some other source from which to collect the money, a guarantor, other non-collateral assets. But that's the hard decision, I think, that the creditor has to make, whether to go judicial or non-judicial. Because the non-judicial is fast, right? You're in default, I got 90 days from the notice of default, I've got another 20 days, notice of sale, I own the property. Okay, what does that get you? It gets you the property. So, which is great if the property is worth enough, but it's not it doesn't necessarily solve the problem. And this is where, this is an interesting topic from a bankruptcy perspective because there isn't much to say, in the sense that the deficiency judgment, by and large, will be discharged in bankruptcy. So, unless there's fraud, given all things being equal, if the borrower goes into bankruptcy, there is no possibility here of a deficiency. So it's not a big topic in bankruptcy. And yet here we are. Anyway. So there's a couple of stories that talk about the intersection between CCP 726 and deficiency judgments in bankruptcy. There really isn't a lot on this topic. What's interesting about the one action, using the one action rule is, let's see, where's that? Is that?
Yeah.
I've lost the
Where do you want to go?
currents.
Forward. Yeah. Give us a second, guys.
We move things around.
Yeah, okay. There we go. There you go. Now it's yours.
All right, okay. So 726, which is the one action rule, doesn't appear a lot in bankruptcy court, but it sometimes becomes adjacent when a borrower goes into bankruptcy and the creditor wants something. So there's this decision called Kearns versus Transamerica from 2004, which has a very interesting explanation of the history of the one action rule. And it talks about this law as the cornerstone of California's complex web of foreclosure and anti-deficiencies laws. And it really is a complex web. And you see in one of the things we talked about, the harsh results, you see in many of the cases that the court ties itself in knots to avoid really harsh outcomes.
The bankruptcy court.
I'm sorry?
The bankruptcy court.
Not just bankruptcy court. A bankruptcy court applies California law in this field. This is not federal law. It's non-bankruptcy law gets applied in bankruptcy court with respect to real estate. 726 has been construed to mean that the secured creditor must, in a single action, whatever that may mean, first exhaust its security as a condition of obtaining the deficiency judgment. And this is used either as a shield, as an affirmative defense, when the creditor sues the debtor for judicial foreclosure. Then you say, now wait a minute, you didn't include all of the security. You have to throw everything all the collateral needs to go into this lawsuit. Okay, remember we're talking about a lawsuit, not a single foreclosure. Or later, the debtor can use this as a sword to say, hey, wait a minute, you didn't do it right, you violated the rules, you lose your security. Which is a serious sanction to the creditors. Yeah.
So all security, would that be back to the guarantee and the guarantor?
Well, the guarantor might not
just-
have filed for bankruptcy.
Or just security?
I think all the
Real
collateral,
security.
all collateral.
Not guarantees, wouldn't be considered collateral.
No.
Well, the guarantor is, what she said, not in the bankruptcy. So,
But this isn't a bankruptcy. I'm saying in your judicial foreclosure action,
Pre-bankruptcy.
you
Right.
have to identify
Well,
and
okay.
include all of the.
All right, but in your state court, you have a judicial foreclosure action. Something happens and there's still money that's owed on the loan. The lender could go after the guarantor for that balance that is owed on the loan, correct?
Well, you are asking a question that has been battling for as long as I've been an attorney, which is the question of can they go after the guarantor and bypass the security and say it's now your problem?
Well, what if they have had the court supervised sale of, this is a commercial deal, they've had a sale, they're doing a judicial foreclosure, but there's a guarantor sitting out
A
there.
judicial foreclosure sale. Now the proceeds would get applied, and now they would then give the judgment for the deficiency as we've defined it. And yes, the guarantor would then be subject at that point, right? Because they owe the debt as well.
Right, that's it. The
You probably
guarantor-
made them a party to the case when you filed the judicial foreclosure, so you don't have to file a separate suit to go after them.
That's a good
That's what
idea.
I've seen.
I mean, I'm assuming that you would name, I mean, I've never
Name
done it,
everybody.
but I think you'd name everybody and their mother, you know, to
It
make sure
saves
that you
time.
cover everybody.
Most
Yeah.
guarantee agreements say that you don't have to resort to the security, you can just go straight after the
Yeah.
guarantor.
Which, as you know, I assume, because this is not a class on suretyship, is directly contradictory to California law. So they're trying to get you to waive the law, and then the bank has a very powerful lobby that says you can waive the protection that was given for the very purpose to make sure you can't do that. And so the courts then have played all kinds of games about if you waive the right of subrogation, because the guarantor always has the right to go after the borrower, but if the borrower is judgment proof, oh my God, that's beyond the scope of an anti-deficiency. But it is a great course. And I'll be there if you teach. No.
Hell no.
But I'm still trying to get my hands around what would be the other security? Fixtures in the building? Or is it?
A second piece
Real
of property,
property, okay.
you know, cross collateral.
Cross-collateral.
But, you know, Kearns is an interesting case, because it's one of these mixed collateral, okay? The debtor borrowed money, and it was secured by both the vehicle and the home.
Oh, boy.
That's interesting. Okay.
You don't see that. You know, this is a case from 2004.
How much money did the debtor borrow?
It wasn't a whole lot. Was it $30,000, $40,000? You really don't see these. You know, I'm a debtor's attorney. I've been a debtor's attorney for over 30 years. You don't see them very often. I think because they're missing.
But what I will say is what you do see is that the lender is holding money in a pledged account. And so if you substitute the cash for the car, you've got the same kind of mixed collateral. I always tell the joke that my dear friend who was doing this for most of his career, whenever he got a mixed collateral foreclosure, would say, should I call my malpractice carrier now or wait till it's over? So, all
Like
that
the
being said,
SBA
beyond the scope, but what
Right.
we are talking about is it was a mixed collateral case and they took the car.
And then, well, so now the debtor filed for bankruptcy. So that discharged any deficiency, right? So what the bankruptcy does is it says the liens pass through bankruptcy. As long as you hold on to the house, you hold on to the car, it still has the lien unless you've messed with the lien in the bankruptcy, which is a different story. But assuming there's no change, then the liens, what is known as pass through. What the bankruptcy helps you shed is the deficiency potential if it's ever foreclosed upon or repossessed. So your personal liability is discharged. Post bankruptcy, the debtor defaulted on the loan, and Transamerica first repossessed the vehicle.
Okay.
Got whatever they got. Some years passed, and then the debtor sold his home. And there's still a deed of trust. Transamerica still had a deed of trust. They put in a demand in escrow for the balance of the loan. Debtor went back to bankruptcy court and say, hey, you violated the one action rule. You took a one action against the car, you're not entitled to take an action against the house.
Did that work?
No.
Nice try.
So, so this is referred as to the one action security first rule. But there is no requirement that they operate in a particular sequence. Now, this particular case, a little bit turned also on interpretation of the UCC because it was a car. But I think this equally applies to any situation where you're holding a CD or anything like that. However, it has to, okay, you will see in other cases that if you do it first, you could lose your security. But in this case, since it was post-bankruptcy, they could take their different collateral, their mixed collateral in whatever order they wanted. An action, the word action that appears in CCP does not include a non-judicial foreclosure or / repossession in the case of a car. So action in this context means lawsuit. So if you can do these things without legal action, you can do whatever you want to do. It's
Meaning the lender can do
the
that.
lender can do whatever they want to do in whatever order that they want to do it, as long as it doesn't involve a lawsuit.
So the debtor files for bankruptcy. The debtor gets discharged. The debtor still has his car in his house. The lender then says, I repossess your car and I do a non-judicial foreclosure on your house and I get my money. And then the debtor is just free of any deficiency.
America, ain't it great?
It's the bank gets it, always gets it. But I guess as much as they
no,
can.
but the debtor was able, okay. Now, if the debtor has actual equity in the property beyond what is owed to the bank, then they need to take other action
Right.
to make sure that the property isn't foreclosed.
What if, so if the debtor has a homestead in bankruptcy, say the property is worth something within the homestead exemption at the time of the bankruptcy, and the debtor is discharged in bankruptcy, and then 10 years later, the bank says, I'm going to foreclose now.
The homestead does not protect you from voluntary liens.
Right.
So the homestead only protects you from non-voluntary liens.
But it does-
So the mortgage is a voluntary lien.
Right.
So if you gave the bank your lien, the homestead is meaningless.
But for that excess, for the equity over and above mortgage, maybe that's within a homestead exemption?
Well, that protects you from judgment liens.
Judgment.
So if you have your house worth $1 million and the mortgage is $500,000, and so you have $500,000 worth of equity, and then you defaulted on your credit cards or your homeowners association or whatever, and they put liens on your property,
Right.
okay? Then you have to remove those liens in bankruptcy to protect your homestead exemption.
Okay.
But the bank, the lender that you voluntarily gave the deed of trust to, doesn't care about the homestead exemption.
Okay.
But as a debtor, if you are essentially at risk of losing the property because you have equity, because even though the creditor doesn't have legal entitlement to a deficiency, right? They can't do a deficiency. But in practice, if you don't stop the foreclosure and they buy it at the foreclosure sale for they
The
credited,
loan, yeah.
you're out.
Or you
They're
have the
get-
group
they're
that
getting
used to
the
be at
equity.
the courthouse that jury rigged every bid to make sure there were no overbids ever. They got all arrested.
That it's not always fair, and debtors don't always, David is a bankruptcy attorney as well, and many of our clients are depressed, and they can't act. And we get the call on the eve of bankruptcy, on the eve of foreclosure, when they should never have let this get this far. And the question is, well, why did you wait at least 3.5 months before you called an attorney? And there's never a satisfactory answer, because the answer is, I was depressed, I couldn't get out of bed. Right? That's in most cases, that's the real answer. So if there is equity that would be otherwise available, you have to file a Chapter 13 bankruptcy or a Chapter 11 bankruptcy in order to fix the loan problem in order to retain your equity.
What was that question? Because can the debtor take an offensive position and, after there's a loan and personal guarantee and say, okay, look, I'm gonna wipe out this personal guarantee. I'm gonna take the first shot. I'm gonna go file bankruptcy, get a discharge. I wipe out my personal guarantee, stay current on the loan. Can that be considered an event of default on the loan to trigger anything? I don't think so, right?
No, because there's the law says that even if you have in your deed of trust, and many older deed of trusts have, filing bankruptcy is an act of default. That's not effective. That's unconstitutional, right?
And I'll add that a lot of leases still have that provision, and whatever.
Yeah. It just is.
Every contract I use now.
So that's really what. So that's the answer to the anti-deficiency. The answer to the guarantee is to file bankruptcy beforehand. So that's that.
Gotcha.
Okay. Did that all make sense?
Somewhat.
Do you see a lot of these fights like with an SBA secured loan, since the SBA takes everything possible as security in addition to the land? 'Cause they'll take out maybe make you take out a life insurance policy written back to them.
Oh my God.
The SBA is an interesting, as an aside, the SBA, and this is something that right now is a hot topic, because one of the big drivers into bankruptcy these days are loans that were given during COVID called EIDL loans. And these loans were given so haphazardly, you have no idea. They were given theoretically for businesses, but a lot of people that just, because, everybody's got an LLC, right? So that made them a business. So people got these loans. If they were over a period of the 2 years that these loans were being given, the rules were constantly changing. We won't take collateral unless it's over 100,000, 200,000, 500,000. Okay. I have not seen a single deed of trust on these EIDL loans. What we're seeing are UCC1 financing statements filed with the Secretary, maybe filed with the Secretary of State.
My clients, they never even recorded the UCC.
They didn't even, I'm saying maybe recorded. Many of them weren't recorded. So now you've got a restaurant. And the other day, I talked to a potential client who has a furniture store. And there's a EIDL loan, UCC, secured by the furniture. Now he wants to sell the business, who is he supposed to call to get a release of the lien? So it's essentially impossible to sell a business that has one of these EIDL loans. It's impossible because there's nobody to talk to release it.
We're doing one right now. It should
Well, you
close
can
next week.
sell it, it's just, you gotta tell it.
We're taking subject to the.
So you're taking it subject to the EIDL.
But the
Now,
SBA may never end up doing anything because you can't get a release, so you just.
so interestingly, one of my clients, they didn't sell the business. They let the landlord take the lease back with all of the pertinent equipment that is subject of the security. Now it's the landlord's problem. Now the landlord can go and rent it out to a new restaurant. Hey, fully furnished restaurant ready for you to move in. I don't know what's going to happen, but it's not my client's problem. My client divested themselves of the security by having it repossessed by the landlord for a default.
So the landlord's security interest was superior to the lender's?
No, not for.
Possession is 9/10 of the law.
The question is
Whatever
whether
it
they
is.
don't normally never do anything because they've just written them all off. There's too many that are gone bad.
So,
But what I see more is like the SBA 7s and whatnot, where you've borrowed from the SBA to buy land in a business, so you've got cross-collateralization everywhere, across, your land, your business, your fixtures, and then you run into a problem when things go south, because the SBA has all different ways, things they can go after, so I have no idea how it plays out. Because I just send it to David Arrieta and let him deal with it.
Well, eventually they might, if you don't file bankruptcy, they might eventually take your Social Security.
Ooh.
Right? I mean, so they're handing this over to the Treasury. And I've got clients who keep on getting letters. Your loan has been transferred to Treasury. And then your loan has been taken back from Treasury. Your loan has been sent to Treasury for collection. So I think the
How much
answer is,
collection is there?
I'm sorry?
How much collection is there so far?
I don't think there's a whole lot of
Who's
collection.
collecting?
There just isn't. They're sending out bills, but they're not actually doing anything. Occasionally, they'll show up in the bankruptcy, they'll show up at the meeting of creditors, or they'll tell the Department of Justice, the U.S. trustee who shows up to the meeting of creditors, and will ask, what did you do with the money?
Right.
Like, I used it for business purposes. Okay. Like, I'm being the neurotic bankruptcy lawyer. Before I filed bankruptcy with them, I was like, okay, I want a spreadsheet, everything you did with the money, have your QuickBooks statement so I can give it when they ask for it. They don't ask for it. What did you do with the money? I also send people away because that's my question number one. I have this EIDL loan, okay? What did you do with the money? I bought crypto.
Maybe crypto is a business.
Okay, are you in the business of crypto? No. I'm like, go away, don't file bankruptcy, hide under a rock. That's my answer. Now, maybe they go to David and David will file bankruptcy for them. I don't know.
As long as the right price.
This is insane because you're asking for trouble. Although recently I had a case where there was $1 million SBA EIDL loan, and it was not properly spent. But we had to file the bankruptcy in order to save the house. And I have in my fee agreement very clear, if you get sued for non-dischargeability by the federal government, I'm not responsible, and you accepted this risk. Nothing. They got it discharged.
Dog is
Could
good,
the
right?
feds come back under a fraud theory to reopen, or no? Or is it?
Not if you file bankruptcy. Now, they've put into the statute of these EIDL loans, they've got 10 years to collect. They have 10 years. So we don't know how many resources the federal government is going to put into this to collection. There are so many of these loans that are outstanding. Boy, we really got off topic.
This is fascinating, and I'm just processing, because I'm more the real estate, and I'm just, all I can think of is deeds of trust, and, okay, so if there's a UCC 1, there is still a valid lien until the statute of limitations runs on that, and if someone decides to come in and take that equipment or furniture, by God, they've got a valid lien on it, and they haven't been paid. So, the question that was in my mind, okay, because I can tell you chapter and verse what the statute of limitations on a deed of trust is, and all things
60
being equal,
years.
all things being equal, yes, unless it's an exception. How long is the statute of limitations on a UCC 1?
I don't know. 7?
Well, they're only good
4 years?
I think it's 4. It's
Well, but the loan itself could be
But
lower
is it
than
10
4.
a
years?
loan plus 4, I think, because
Yeah, but then you gotta know how long the loan is.
So it's longer than 4 then, it's the term.
But the
of loan.
UCC itself expires if it's not renewed within a period of time. I don't remember.
think
the
that's
date.
10 years.
And then you have to file an extension. So if you do that, your UCC lapses if you don't extend. So then you're back into your breach of contract,
Ugh.
straight action in court.
Well, but that would be the 4-year
Would be
from
the
the breach,
4-year.
or maybe 6, depending on the note. But now that's a great takeaway from this, is if nobody is smart enough to do the extension of the UCC 1,
It lapses.
maybe we've got something that we could tell people.
Yeah, because it lapses at that point and you don't have a security interest anymore.
I mean, one of the things that we can do in bankruptcy, and we'll talk about this in connection with this next case I'm going to talk about, is called a valuation process. And so if there is, let's say, an asset with a UCC 1, the restaurant, the furniture shop. And the loan is for $100,000, but the equipment's only worth 10, okay? So you can do a Chapter 13 bankruptcy, and you can do a motion to value. This asset is only worth $10,000. That's what I'm gonna pay you over 5 years. That gets rid of the lien. And so you've just given yourself a 90% discount on this lien based on the value of the asset.
That's
With cars, that's a little more complicated. It depends how old the loan is. The car companies had pretty strong representation in Congress. So car loans get special treatment. But we do this all the time, especially when, it's not unusual for people to have a car loan, and then halfway through paying it off, they get a new loan, they refinance it, and now they roll that car loan into the new car loan, and then that car into another loan, and now they've got a car worth $20,000 and they owe $35,000. And the interest rates are phenomenal. And then, or there's a whole industry called title loans. I don't know if you guys that don't do bankruptcy, maybe you've never heard of this horrifying security document. You can take your car that's paid off and you can borrow money against it. And these things run at about 100% interest.
Is that legal? That sounds like.
Not if you or I do it,
Oh, but the creditor.
but they can do it.
They're exempt lenders.
They're exempt lenders. Like this is highway robbery. So again, we can put them in bankruptcy. We can say the car's only worth $2,000 and that's what I'm paying.
And how often can you do a 13? However many years? I mean, is there a limit on how many times you can get discharged in a chapter? 13?
Yes. 13s there's 4 years between 13s.
Okay.
I think it's 4 years, right? It's between filing 13s.
Yeah.
And occasionally you see people in multiple cases because it has to do from when you filed, not from when you were discharged. So, anyway, let's get back to our subject before
We digress.
we digress. So this case, Rabobank versus Beardsley, is an interesting case. The creditor in this case is in third position. There's a deed of trust, there's a tax lien, and then there's this property.
You did it.
It is unclear, I'm sorry? It's unclear from the record in the case if the property was worth enough to cover the lien at the time the loan was made. And the case law seems to indicate that might make a difference but we don't know. At the time, the debtor, so then the senior lender does not foreclose. If a senior lender forecloses, and so when they foreclose, judicially or non-judicially, the junior lenders
Is it sold out?
is a sold out junior. A sold out junior can go against, they can sue on the note. So basically they get an automatic deficiency, right? It's 100% deficiency, and they can go into bankruptcy and file a claim or do whatever they want to do on their sold out security. In this case, the senior did not foreclose. The debtor files a Chapter 11, tries to sell the property for a year or so, isn't successful. The case gets converted to Chapter 7. The Chapter 7 trustee tries to sell the property for a year or so, and then says, there ain't nothing here. This property isn't good enough. There's no water. Not enough water is coming to this property in order to do the development at some place in Monterey area. Can't work.
There is not enough equity in the property to cover all the debt secured by the property. So the
Plus,
trustee,
right, in bankruptcy, a bankruptcy trustee will sell property if there's enough money to pay all of the lenders, a homestead exemption if there is one, plus something
For the trustee.
for the unsecured creditors and the trustee. Okay? Sometimes judges will allow carve-outs. If the lender really wants to sell the property in bankruptcy because they get all sorts of protections by a bankruptcy sale, the trustee will say, but I need something to give the creditors. And those are frowned upon, but they do happen. There wasn't enough money here for anything. The trustee was sitting on $300,000 that was going to go to the unsecured creditors from other assets. The trustee files a motion to abandon the property. Now, in bankruptcy speak, what abandoning the property means is it takes this real estate and says, not connected to the bankruptcy. At the same time that they did that, and what they wanted was to quickly get rid of the property and distribute the money to the unsecured creditors, pay the trustee, the trustee's fees, the trustee's attorney, the trustee accountant, close the case quickly. At the same time, Rabobank says, hey, wait a minute. I want to participate in the payment of the $300,000 to the unsecured creditors. So they file a motion in bankruptcy court to value their lien at zero. Those two hearings came up on the same calendar. And the judge said, no, I'm just going to rule on the abandonment, and then which takes the property outside of the estate, and I can't do your valuation. You, Rabobank, you go to bankruptcy, you go to Superior Court and do whatever you want. Essentially, the judge is telling them, go do a judicial foreclosure.
On property that's not worth it.
In property, well, so presumably the way it should work is that you get your judicial foreclosure, you go to Superior Court, and the Superior Court issues an order, the value of the property for you, foreclosing creditor, is zero. And everybody acknowledges in this opinion that that would be the outcome of a judicial foreclosure. But the bankruptcy court is saying, go do it. They appeal, Rabobank appeals the denial of their valuation motion. They don't appeal the decision on the abandonment. So the appellate court, which is the bankruptcy appellate panel, which is comprised of bankruptcy judges, says, well, it's too bad, so sad, Rabobank, because technically, once it's out of the estate, we can't do anything. You're out. And there's no requirement in the bankruptcy code to balance the equities of any particular creditor when making the decision to abandon property. It's the estate writ large, okay? You don't get to choose, well, it's good for this creditor, but it's not good for that creditor. And so then on the technical reason, their appeal was denied. There's a concurring opinion in that case that says, look, this isn't fair, this isn't reasonable. We know that if they went to Superior Court, they would be worth zero. There's no reason to there's no reason to do an act which would be meaningless. The bankruptcy court has the jurisdiction, could have decided essentially a 726 motion to value, to say that they're worth, that their security is worth zero.
What would they have gotten if the court had ruled that way?
They would have gotten a share of the $300,000.
A share, not the whole, but some amount.
More than zero.
More than zero. They would have gotten a share. They would have gotten a share. And where was I?
Concurring opinion?
Yes, please.
Okay, so let's take this one and take a step back. What was Rabobank actually asking?
To have their
Give us the
liens
money and let us foreclose later. What is the thing that 726 says you absolutely positively cannot do? You have to go after the security first. Therefore, Rabobank was asking for something that would completely violate 726, but using the bankruptcy court as a means to achieve it, as opposed to asking for relief from the stay, doing their 726 foreclosure, but what would have had to happen now in the bankruptcy court is a stay of the bankruptcy proceeding so that they could proceed. Yes?
Couldn't Rabobank have asked the court to strip their lien? I know the debtor can ask to strip a creditor. Can the creditor ask that their own lien be stripped and to become an unsecured, in which case
Well,
they've
that's
given
what they
up
were
the-
doing. That's what they tried
Well,
to
that's
do.
what, but you
And
were
the
saying they
answer
would
is
still have their lien and could still terminate.
726 does not allow that. They took real estate security. Of course, all assets of a debtor are available for a judgment. If they had chosen to just go unsecured and then, go ahead and enforce it by getting a judgment lien against the property, then they would have been an unsecured creditor or whatever in that mode. But literally the process for them would have been to have a foreclosure sale, a judicial foreclosure, bid $1 or, some token amount, and then ask the judge to give them my daughter, but we don't do that now. That then get a deficiency judgment for the entire loan minus $1. And that would have then been something that they would have had.
They could come back to bankruptcy court, have their proof of claim, be
There you
deemed as an
go.
unsecured creditor, and participate in the.
But by then, the bankruptcy's done, the money's distributed, and you're SOL.
Right. Well, and there's I actually know the attorney that represented the trustee in this case, and I called him up the other day after I was reading. I'm like, Charlie, I want to take you back 15 years, and he said, in the CODA, because for a variety of reasons, the case didn't close, and at the end, Rabobank did get paid. So they did ultimately get paid, or at least participate. I don't know if they got paid in full. But part of the problem, and when you read this decision and you read the other decision, it's a case of wanting your cake and eating it too, because you cannot get a money judgment and retain your judgment lien and retain your deed of trust.
Well, that makes sense.
What about if you did a deed of reconveyance, kept your promissory note?
Well, interesting. Because I said to Charlie, I said, why didn't Rabobank just reconvey the lien?
Yeah,
No can do, right?
no?
Why can't the bank reconvey the lien?
Again, that was an election they made when they took a real estate secured loan. I'm just arguing the debtor's position. That they had that choice at the time. It's not something they can waive later and say, we wish we
really
would have
mean
done it the other way. But what I want to ask the bankruptcy practitioners, how do you handle a contingent claim? Hey, if something happens, someone is a guarantor, okay? And for whatever reason, a guarantee hasn't been called yet, but it's prospective, and at the same time, the person who holds that guarantee, why am I asking that? Because I'm saying that's what I see Rabobank. They have a contingent claim that is as valid as the day is long, against this debtor, but they have to go through a judicial foreclosure in order for the contingency to be removed. Does the bankruptcy proceeding wait for that? All these other creditors who want their money, I don't see why they should be penalized for being required to follow the law that the court is requiring them to follow.
Well,
Are you assuming that the loan is still in good standing and the guarantor filed bankruptcy for other reasons?
No, I'm just using the example of if a guarantee has not been called and the guarantee of it when the guarantor goes into bankruptcy is saying, wait a minute, we want a share of this because we don't know if this loan is going to go into default or not yet. So it hasn't been manifested.
well, if it's not in default, it's not in default. We're only talking about loans
But
that are actually in default.
Okay, but I'm saying, why should you get
But
screwed out of
the
something that hasn't?
guarantor. But if I guarantee your debt,
Yeah.
and I know that you're about to go, I'll file bankruptcy in order to strip my guarantee from the liability. So
It
then,
does,
so that's the bankruptcy for the guarantor.
Yep.
But
Maybe my
What-
analogy wasn't good.
But what happened in this case is what often happens in bankruptcy cases. So the trustee took of the $300,000, set aside what Rabobank's share would have been, and distributed the rest, and held onto it while Rabobank went and did whatever it was going to do. Because there is the right to do that. The problem is,
There you go.
the problem is,
But
from
then
the
the
trustee's
trustee's benefiting the
perspective,
creditor.
that doesn't close the case.
but they're also benefiting one creditor over the others, because they could have just closed
No,
it. and
if that money ultimately doesn't get distributed to Rabobank, it'll get redistributed to the other creditors.
But if they distribute it before Rabobank gets to the end of their portion, they could have just closed the case, distributed it. Rabobank, you didn't move fast enough, tough luck.
That's what I'm asking.
I think that's a risk, and I think what the BAP was here struggling with is that the trustee said they wanted to close the case quickly, and yet it still dragged on. And I think that ultimately, and interestingly, the trustee's attorney was quoted in the opinion as saying, "I won't be heartbroken if this case is overturned, if the decision is overturned," because it was clearly. There was clearly an unfairness here to Rabobank in a practical sense.
Yeah.
But the law is what it is. And you can't just wave your hands out and say, I give up my security.
And
Because the deed of trust gives certain protections to the debtor. And now the debtor wasn't about to sign off. The debtor was, standing there in front of the trustee saying, also objecting, because they didn't want, they were hoping that maybe this property will ultimately come back to them, and then maybe 10 years hence it'll be worth more. They didn't want it foreclosed.
I'm going to give one other possibility as a way that this could have gone down. As a junior lien holder, you have the right to pay off the senior lien and be subordinated subrogated to all of their rights. So had Rabobank been so inclined, I don't know what the property tax lien was, but that would be the second position. They could have perhaps paid that off and then foreclosed on the second. We're assuming there was enough money to get that out.
I think there wasn't. I think the problem was it wasn't even worth enough to pay off the first.
Never mind.
So, but as a theoretical construct, you're absolutely right, is that Rabobank had all sorts of options, and it didn't resort to any of them other than going into bankruptcy court and pretending to do a judicial foreclosure. And that's the problem. That's what I mean by wanting your cake and eating it too. They could have done a non-judicial foreclosure,
Right.
and
They
then
didn't.
if
But
they
that would have, then they
That
got
would have
nothing.
stripped
Then
them.
they got
There's
nothing.
no deficiency.
They had to go.
No, it's not. It wasn't a purchase money.
No.
It wasn't a
No, but
residential.
it's a non-judicial.
Non-judicial.
You have to do judicial
Non-judicial
to get
is, you're done. Judicial, I think you mean judicial. They could have asked for relief of the stay, done a judicial, because if they did a non-judicial under
done.
580D,
They're gone.
they'd be
They're
done.
done.
Right.
Okay, so all of that being said, had either the first or the second foreclosed, and now we know why they didn't, they wouldn't have had this problem. They'd have been a sold-out junior, and they could have just filed their claim.
I mean, I think in a practical sense, even if I don't know if they could have done a general unsecured. It's a conundrum. There's not a simple answer. That's why that's why it's a case. There's no simple answer
We move
to
on.
what's right. Yes, let's move on, right, okay. The next case is in this area, in the family law and bankruptcy context. The wife in the divorce got an equalizing payment of $100,000 secured by a note and deed of trust on the husband's property. He defaulted, and he also had a business, and she did a debtor's examination. She did
Wow.
a debtor examination and tried to have a receiver put in place, and she got $83 from this exercise. And then he filed bankruptcy to stop the putting in a receiver. She sues him for non-dischargeability, and then not only does she lose the non-dischargeability case, the judge says that you violated Rule 726, CCP 726, and you lose the security, you lose the deed of trust, and you lost the note as a sanction.
That's terrible.
That's terrible, and it got overturned on appeal that says that under California law, you can only lose the lien for violating 726. You don't lose the debt. In a coda to that one, for whatever reason, he got his discharge, the debt was wiped out, the appellate decision was mooted. So appeal of this got mooted by the actual discharge. So we don't know how it would have gone further. But the point of this is the harshness of the result. When all you got was $86 on a $100,000 debt, you lost a serious security. So as a creditor, you have to be very careful on what you do, what is deemed an action. So
I got the other 99,917 out of the malpractice case. The attorney took the debtor's exam.
Going back, if she did a debtor's exam, she'd already gotten a judgment.
Through the divorce, I'm assuming.
Well, maybe that was a violation of the 726.
That she did. She moved for appointment of a receiver, did a debtor's examination. She took legal action other than foreclosure of the security. And I think the reason she did that was because the security was worthless.
Her husband was worthless, yes.
Her husband and the security. Okay. The next case I wanted to discuss briefly is In re Bell, which is an even older case. The debtor files for bankruptcy and the secured creditor files for relief from stay to foreclose. That all they're asking is, we want to foreclose. For some inexplicable reason, the relief from stay motion devolves into a trial on the debt itself. And at the end of the trial, the creditor ends up with a money judgment and a deed of trust. So obviously this goes on appeal, and this is overturned as a violation of 726, that the only remedy is a judicial foreclosure to get a money judgment. You can't get a judgment and retain the lien. So, can you go my next one? And so I think, the big thought here is when you represent creditors in bankruptcy, you have to be careful of what you do, because actions have consequences. And whatever actions is, there's not a clear answer. It is generally a lawsuit, but is it filing a motion for relief from stay? Is it filing a proof of claim? If you file a proof of claim, that has consequences to jurisdiction. So, as I said before, generally speaking, liens pass through the bankruptcy unscathed. So, I think much thought has to be put into whether you put in a proof of claim, whether you file relief from stay. Maybe you just wait one more month and you'll be able to foreclose without, because the whole process in the Chapter 7 at least is a 3-month process. And if the trustee doesn't take the property for selling, the moment the debtor gets their discharge, the property is released from bankruptcy, and you creditor can do whatever you want. Okay.
I think we're pretty much
done.
through our materials.
Okay.
And Darya found this case, Espinoza versus Bank of America, that was written at the time of the short sale statute, had just gone in, and so it actually talks about it, but says it hasn't been, the loan did not apply to it. But it was a good summary of how the short sale would normally work, but for 580E, which says it doesn't apply to residential property 4 units or less. but they didn't apply it in that case because the law wasn't retroactive. I'm sorry, it's so confusing, but it is, it was a good summary.
Right. Well, and I think one of the things that some of these cases talk about is, and this is mentioned in the opinion in Rabobank and other ones. The problem is, what do you do when property is no longer worth anything through no fault of the lender
Or the borrower.
or the borrower? It just is. And there's a case from the 19th century, because so this law has sort of been long in developing in California, and it has to do with a crop. Okay, so if the loan was secured by the crop was destroyed by I don't know what, and then the lender went straight to the guarantee, or to try to collect in non-collateral assets, and said, hey, you can't do that. You have to go after the security, the collateral. Well, there is a principle, I guess, in California law that if it's destroyed or doesn't exist anymore, then you don't have to do that which is impossible to do. Where's the line between the crop that was destroyed by hail, let's say, and the property just lost value? For what? Because they couldn't get the water to they couldn't get water to the thing. Where's the line that says you still have to go through all the machinations of 726 to get a judgment, and when can you avoid that? The bankruptcy judge, or one of the in Rabobank, one of the BAP judges that the concurring opinion seemed to think that this reduction in value that was obvious because there were appraisals and that going back to court to do the judicial foreclosure was too much because it was a nullity. Like the outcome was predetermined. It should have been handled in bankruptcy court. I don't know if that's the right answer. It was the practical one, which the judge in the bankruptcy court declined to do. But that's the where are you between destruction and loss of value for other reasons?
And I would answer that from the borrower's point of view, is if there's any value at all, I want it applied to the loan. As opposed to there is nothing left, it's been destroyed, and this is not a loan case, this was a tax case, but it was just one of those things that happens in the Loma Prieta earthquake. I had a client who took a complete loss for loss of her property as a result of the earthquake, and of course she got audited because the auditor said, I don't think you understand, ma'am. You can take a loss for your house, but you can't take a loss for the dirt. And she says, I don't think you understand. She holds up a picture of her house on a lot that is on a hill, and she holds up the same, there's no more hill. It's gone. And he looked at her and said, okay, no change audit. So, bottom line, if there's any value at all, you get it applied to the loan. It's the sold out juniors and it's the complete crop destruction. And I guess I didn't show this slide on the 580E. I thought I had, and I'm sorry if I'm dizzy. But so this is the back to the short sale. So 580E, this is the new law. No deficiency shall be owed and no deficiency judgment shall be requested upon a note secured solely by a deed of trust or mortgage for a dwelling, again, of not more than 4 units, but it doesn't say owner-occupied this time, unlike 580B, in which the trustor sells the dwelling for a sale price less than the remaining amount of indebtedness with written consent of the holder of the deed of trust. Okay, so remember I alluded to that at the very beginning as one of the new laws. So only residence short sale, 4 units or less, but look at the carve out at the bottom. D, this section shall not apply if it's the owner of that property, i.e. the trustor, is a corporation, limited liability, limited partnership, or a political subdivision of the state. Only a residence, but apparently, I don't know if they left out owner occupied on purpose or not, But just know that if the lender consents to a short sale, they're done, if you're selling a residence. Okay? That's new. In
Except
any
for the
other
asset
context, that's
protection
what-
guys who put houses into LLCs because they think it will protect the asset. Now
No,
they've
because
done.
it's saying trustor, not assignee of trustor. When you take out the loan, you're the trustor.
Right, but if the trustor.
As an individual.
Oh, you mean
And
if you
then-
pitch it?
and then
No, no,
pitch
no.
it to a court.
Oh, I see what you're saying, yeah. What he's saying is that normally you would put it in the LLC after he took the loan. But understand, this only applies in that context. In any other context, if the lender says, yeah, okay, I'll take 25 on my 50, you still own the other 25 unless they give you a release.
Or you file bankruptcy.
Or you hire her. This time I think we're really done. Yeah.
Any questions?
So I'll add these other two statutes, 580A and 580C are basically just equalizers that are in the anti-deficiency, but they say you can add the cost of the sale into the sale itself, so I'm not spending any time on it. And that is us. So anybody got any questions or anything? This was fun and really, this took me out.
In a UCC1 sale, is there a fair value hearing after the sale?
Good thing that's not real property, because
In a mechanics lien, there is fair value hearing.
in a mechanics lien foreclosure sale,
Well, that makes sense.
in bankruptcy court or in
In state court.
really?
So
I mean, UCC, I don't think there's any court, you can, if I'm not mistaken, it's been a while since I've looked at this, but you can foreclose a UCC one without judicial action. It's like you have to post it, you have to give them 30 days notice. This is how people take over stock, especially when you have stock. I think they use this especially for stock security. When, you can take the stock in the pledged stock, with just notice and,
But that's where you've got a pledge agreement, not a UCC. The problem with the UCC is most of the police won't do anything to go help you seize your asset without a court order.
Yeah.
So then you gotta go to court, because the police are like, no, we're not.
yeah, that's,
we're not
on
making
a practical level, the sheriff is like, I don't know what to do with this.
Yep.
I need a court order. Go get a court order, so.
There's that prohibition for, you said short sales and residences. What about if it's individual homes or vacation homes, not an LLC? Does the same rule apply?
It's residential.
Single, 4
Single
units or
family,
less.
residential.
Whether or not it's
Doesn't matter.
or vacation.
It doesn't have to
A
be
dwelling
owner
of no
occupied.
more than 4 units. That's all it says.
Alright.
And so, damn.
Yeah, not a
But
commercial
interesting,
building.
the word dwelling,
Don't operate your dental practice out of it. if you can.
recently I was involved in a case and the judges were just like all tripping over themselves. Dwelling versus residence, and this had to do with an exemption question. Is a dwelling a residence? Is a residence a dwelling? Is it because, and two different, and on the same case, on the same problem, a judge in San Mateo County and in Alameda County came out on the opposite side, read the statute differently. So,
Interesting.
like, what does dwelling mean? What does residence mean? I think one
But
thing,
it's so interesting, because I
Yes,
would
that's
have
it.
read that as a dwelling is a building in which people could reside. So all residences would be dwellings, but not all dwellings would be residences. But clearly, I'm not a judge.
So on the issue is, if you had a home office, do you get to argue that some portion of it isn't protected because it's a business and not a dwelling or residence?
We
Then
don't
you get-
sleep there every night though, so it's a.
Well, dwellings.
But if you're, on your IRS tax return, if you've said 800 square feet of my home is a deduction, because that's my office, and now you've taken a tax deduction,
Well, actually, no. Let me take, because where that does have some relevance to me is 1031s on family farms. You don't get to 1031 to residence, but you do get to make an allocation of the business portion of that parcel. And so, I don't know, but it's damn.
it gets into a weird argument because of that change with a home, since so many people work out of their home now.
now speaking of farms,
Yes.
farms are an entirely different kettle of fish in bankruptcy. And you get to do stuff to farms that you don't get to do to other things. So, for example, bankruptcy judges, for instance, cannot modify mortgages on residences unless it's a family farm. And then they can do that, and they can make like 40-year, they can turn it into the current loan into a 40-year amortized loan, whatever. So there's
I did not know that.
in a special kind of bankruptcy, it's called Chapter 12,
About the 12s.
which are, but they can't be cannabis farms. Although even that's, I think there's some case law now that's maybe changing.
It's illegal
But,
at federal level.
so we can do things for farms that what we can't do for other things.
Never met a farmer who didn't go through bankruptcy at least once. I used to live in Fresno and practice there when I started, so.
Yeah, you don't get a lot of Chapter 12s in the Northern District of California. There just aren't that many farms. I did one years ago out of Petaluma, a small, I mean, as the trustee referred to it as a hobby farm. But my client got most of her income from selling the eggs from the chickens that were running around the yard, and she had ponies. She did pony rides at farmers markets and that sort of thing. And she got treated as a farm, and I saved her house and in a pretty significant way. So that was kind of fun, pretending to be a farm. So.
Thank you, guys.
Thank you.